Hello friends, in my YouTube channel Advocate Amit Kumar Gupta. Today I am going to discuss a very important case on section 68. The name of the case is Principal Commissioner of Income Tax versus Sreeleathers, and this case has been reported in 448 ITR at page number 332, and the matter has been decided on 14th July 2022. The logic of discussing this case is that in this case the court came very heavily on the department that when the assessee gives explanation or when the assessee discharges his burden, where the department is going to penalize the assessee under section 68, then after submitting the explanation given by the assessee, the burden of proving the transactions not genuine shifts on the department. In this particular case, the show cause notice was issued to the assessee because the assessee has taken some loans from 13 parties, for which the assessee has submitted all the documents like confirmation, copy of PAN card, copy of balance sheet to the assessing authority, but the assessing officer brushed away all the documents and alleged that by submitting PAN card, copy of the balance sheet and the confirmations, the assessee cannot absolve from his responsibility from proving the genuineness of the transaction. But the assessing officer has not told the assessee that how the evidence of the assessee is not genuine. The assessing officer has not brought anything on the record that the transactions of the assessee are not genuine and how these transactions do not fulfill the requirement of the identity, creditworthiness and genuineness of the transaction. By simply brushing away all the submissions and explanation of the assessee, the addition under section 68 cannot be made. The court said that the AO should consider objectively the explanation of the assessee. The court also said that it cannot be assumed that there is some illegalities in the assessee's transaction until and unless the assessing officer proves that there is some illegality into the transactions of the assessee or proves that the transaction is not genuine or brings anything on the record that the credit worthiness of the lender or the investor is not there. Only in those cases section 68 can be attracted. The court also said that there was no discussion by the assessing officer on the correctness of the stand taken by the assessee. Only plain allegations were there. There was nothing brought on record how the explanation of the assessee cannot be accepted. In this case, the assessing officer also used the words money laundering. The court said that usage of the word money laundering is a very serious allegation and was uncalled for in this particular case. Money laundering is a very serious offense and there are very penal provisions for this. So without bringing on record or without bringing anything on the evidence, the assessing officer should restrain himself from making these type of allegations. The court also said that there was no evidence that explanation of the assessee was false. So the assessing officer cannot assume that the explanation which has been given by the assessee is false. The primary duty of the assessee is to submit all the documents which are important for describing the identity, creditworthiness and genuineness of the transaction. So once these documents are submitted, now the burden shifts on the assessing officer that the assessing officer should go for verification under section 133 subsection 6, 131 by summoning the lenders or the creditors, but without doing any exercise or without pinpointing the mistakes or the falsity into the documents which have been submitted by the assessee, the assessing officer cannot make the addition very bluntly or in a plain manner, because the consequences of section 68 are very remote and it casts a very heavy tax burden on the assessee. So whenever the additions are made, it should be objectively made. The explanation of the assessee should be objectively discussed into the assessment order. Mere allegations cannot attract Section 68. Friends, this case is very important as far as Section 68 is concerned. Once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus Sreeleathers. Thank you, friends.